the jury. Has anyone read or been exposed to reading newspaper headlines and or articles relating to this trial or its participants? No. And has anyone seen or heard television, radio, or internet comments about this trial? No. Have you read any news headlines or articles relating to this trial or its participants? No. Has anyone conducted or been exposed to any research regarding any matters concerning this case? And have you discussed this case among yourselves or with anyone else or allowed anyone to discuss it in your presence? Okay, yesterday I had a question by a juror, and this is in response to that question. The DVD of the interview with the defendant has been received in evidence. This item will be available for you for viewing during your deliberations at the end of the trial. A transcript of the interview will not be provided. Okay, that's in response to that question. Okay, other witnesses on behalf of the state.
State calls Amanda Osburn.
Okay, ma'am, if you'll come forward, step before the clerk to be sworn.
Please raise your right hand. You solemnly swear or affirm the testimony you shall give to be the truth, the whole truth, and nothing but the truth, so help you God? Thank you.
Okay, please be seated in the witness chair. Okay, ma'am, if you'll scoot your chair forward, you talk into that microphone. It helps us hear your testimony. It also aids in recording your testimony. Okay, Mr. McMaster, you may proceed.
Ms. Osburn, I'm going to ask you a series of questions. If you would, direct your responses to the ladies and gentlemen of the jury, and let's start by telling them your name, and if you would, please spell your last name. Right.
Amanda Osburn, Ozburn.
Ms. Osburn, do you know the defendant, Brandon Bradley?
Yes,
How do you know him?
I was friends with him.
And what period of time are we talking about?
6 months prior to the shooting.
Prior to the shooting of Deputy Bill on March 6th of 2012?
Yes,
Did you spend a considerable amount of time with him?
yes,
Were you aware that during the time frame that you knew him that he possessed and carried a firearm?
yes,
Okay, overruled.
First witness.
Yes, you may.
Showing you it has been marked and admitted as State's Exhibit 8 in evidence. Would you look at that and tell me if that looks like the weapon you observed Mr. Bradley to have during the time that you knew him?
yes.
Where was it that he would carry the weapon?
In his waistband?
Now, do you recall an incident when you and Mr. Bradley were together in December of 2011, driving from the area of 192 toward the Oak Alley area?
Yes,
During that drive, did you have an occasion to see a number of police vehicles?
yes.
What, if anything, was the reaction Mr. Bradley had to seeing the police vehicles?
It's actually relevant.
Okay, overruled.
He was nervous.
Did he say anything?
Mhm.
Were you aware that Mr. Bradley had outstanding arrest warrants?
Yes,
Do you know how many he had?
I don't recall.
He told you he knew that he had outstanding arrest warrants.
Yeah,
Did he tell you what it was he was going to do or what he would do if the police tried to pull him over or take him into custody?
just that he would try to run.
Did he ever tell you anything else?
Not that I recall.
Did he ever tell you that he would, if he ever got pulled over, they're going to have to hold court in the streets because I'm going out like a soldier?
I didn't recall until this morning when you showed me.
But he said that to you at one point?
And
Objection, ma'am.
Okay, is it a different objection that we discussed earlier?
No, Your Honor, it's the objection on the approach.
Okay, she hasn't completed her answer, so I want her to complete her answer, and then you can renew your objection.
can you repeat the question, please?
Do you recall Mr. Bradley making that statement to you?
I did not recall until this morning. I don't recall him saying that, no.
Did you ever tell anybody under oath that he told you that?
Yes, I did.
that was in a sworn statement that you gave to the agents on March 6th of 2012,
Yes,
just a couple days after the shooting?
yes.
Okay, Mr. Verla, do you want to renew your objection?
Yes.
Okay. Based on a court's prior ruling, this statement just given by this witness attributing comments to the defendant should not be considered as a proven fact, but for the purpose of impeachment of this witness. Impeachment means information you may consider in determining the believability or credibility of the witness. Okay, Mr. McMaster, anything else?
Just one thing. Ms. Osburn, do you see Mr. Bradley, the person you knew as Brandon Bradley, in the courtroom today?
Yes,
Where is he seated?
right there.
William? The record reflects that you pointed to. No further questions.
Okay, cross-examination by the defense.
In a moment.
Okay.
Would you like some water?
No, thank you.
I know you recently had a child last week, right?
Yes.
Did you have to go back to the hospital last night?
Yeah. Huh?
Because of,
He's in the NICU, so I go every night.
need a moment, just let us know, okay?
No, I'm fine.
Ms. Osborne, you indicated regarding a statement Mr. McMaster asked you. You said you don't recall Mr. Bradley making that statement, correct?
Correct.
You sit here today, you don't have any independent recollection, any memory of Mr. Bradley ever making that statement to you, correct?
No, I do not.
And Mr. McMaster also talked to you about an interview that you gave to law enforcement when you made that statement to law enforcement. Remember that statement?
Yes.
And there's a lot of things that you told law enforcement, you've told us since then that should not be looked at as credible, right?
Correct.
And specifically the statement that you said Mr. Bradley said, I'm going to hold court in the streets, that specifically should not be looked at as a credible statement, right?
Correct.
You've been very candid about that, open about that, right?
Yes.
In fact, we took your deposition back in February of this year, and you were given a chance to read that statement that you gave to law enforcement, correct?
Yes.
And at some point, you just put it down, right?
Yeah.
The reason why you put it down, you said, looking through it, and a lot of this stuff can't be looked at as credible, right?
That's correct.
And one of the reasons why is you don't remember Mr. Bradley ever making, again, specifically that statement to you, right?
Correct.
And the morning that you gave that statement, that was here in the area, right?
Yes.
In the courthouse.
Yes.
Right? And you were in custody, right?
Mm-hmm.
You have to say yes or no.
Oh,
Is that
yes.
right? I'm sorry. And they had you, for lack of a better term, shackled.
Yes.
And shackled means you had handcuffs on your wrists
And ankles.
and ankles too. Okay. And did you say there were a lot of law enforcement officers talking to you that morning?
Yes.
Okay. And did you say it was 7, 8 be a fair number?
Yeah.
They were talking to you about something else, right?
Correct.
Right. They were talking to you about a home invasion robbery that you were arrested on, right?
Correct.
And at that moment in time, that was a pending case, right?
Yes.
And to your knowledge, do you remember at that point in time, you were potentially looking at, if the case evolved, potentially looking at 30 years in prison, right?
Yes.
It was a very serious case, right?
Yeah.
And you feel that you were, lack of a better term, stormed by law enforcement that morning,
Yeah.
and they talked to you for quite a while about that case.
Correct.
Doesn't involve this case, right?
Correct.
And at some point after that, they wanted to talk to you about Mr. Bradley, right?
Yes.
And you would admit that that morning you were under the influence of drugs, right?
Yes.
You'd been up pretty much that entire night.
Yes.
You were under the influence of the cocaine and Xanax.
Yes.
At that time, I know things have changed since then, but at that time you were doing drugs pretty much every day, not?
Yeah.
And you were doing cocaine on a daily basis.
Yes.
You would do cocaine, you would do, what, about a gram each time?
If not more.
So when you went into the courthouse that morning, you recalled how much cocaine you had done prior to going to court?
Quite a bit, because I was up for the entire night.
And you did some that morning as well before coming to court, right?
Yes.
Like you can't give us the exact amount. It was just a lot, right?
Correct.
And that's another reason why you don't believe the statement you gave to law enforcement should be looked at as being credible, right?
Yes.
Heavily under the influence. Is that a fair statement?
Yes, it is.
You don't agree with a lot of things that you said to law enforcement, right?
No.
After being able to look back sober and read that statement, you can't say that a lot of those things should be, that you agree with this, correct?
Correct.
You would also agree that a combination of the drugs you were on, Xanax and cocaine at that time, would affect your memory as well, right?
Yes.
Were you dating someone by the name of Eric or living with someone by the name of Eric at that period of time?
Yes.
And there would be times that, because you were on that combination of drugs, and sometimes you would ask Eric, did this really happen? Because you really didn't know if it happened or not, right?
Correct.
A lot of times Eric would say, no, that didn't happen, right?
Yes.
Mr. McMaster asked you during the time leading up to March 6, 2012, whether you had seen a firearm from Mr. Bradley. You had seen Mr. Bradley in possession of a firearm, you said?
Correct.
And that he was carrying that for protection, isn't that true?
Yes.
There's a guy by the name of Pookie that was constantly threatening Mr. Bradley,
Yes.
and that boy was carrying the gun at that time.
Correct.
And I know you said you were hanging out with Mr. Bradley for about 6 months prior to March 6th, right?
Yes.
And you guys hang out pretty much on a daily basis together?
Yes.
And during that time, and closer to March 6, 2012, you were doing drugs, right?
Yes.
Mr. Bradley was doing a lot of drugs too, right?
Correct.
And he'd smoke something called backwoods, right?
Yeah.
And that's a way of smoking marijuana, right?
Yeah. Yes.
And that's a lot bigger than the joint, right?
Yes.
All right. Kind of laugh because it's much bigger. I mean, you tell members of the jury what you mean by that? How much?
I mean, as opposed to something this big around, it's about that big around.
How long would it be?
Like that.
Basically take the tobacco out and stuff it with marijuana.
Correct.
And since you were constantly around Mr. Bradley, you could see you smoke that much marijuana, it pretty much impair his judgment. That's a
Yes.
fair statement. It would also make him more paranoid.
Yeah.
Is that yes?
Yes.
You were currently being prosecuted by the state attorney's office, right?
Yes.
There's 2 charges that are pending,
Yes.
grand theft auto and grand theft.
Yes.
I believe we're looking at a total of a possible 10 years in prison on that, right?
Correct.
Can I have a moment?
Yes, you may.
Ms. Osborne, I first want to clear up something. The home invasion that was pending at that time, there was someone else that was implicated in it, and that someone else wasn't Bradley, correct?
Correct.
Boyfriend at the time or some other guy?
It was a friend.
And Mr. Bradley, he saw law enforcement officers back in 2011, I believe it was. He pretty much told you he was going to run. Right? He was confronted by police officers.
Correct.
Run or flee.
Yes.
He never indicated that he was going to shoot them or be violent towards them, right?
No.
Know that I'm not right, or know that he didn't say that?
No, he didn't say that.
Okay. And getting back to the drugs that you're doing at the time, they also would make you paranoid as well.
Correct.
You don't have anything else.
Okay, redirect on behalf of the state.
Ms. Osborne, the charges that are pending against you, you did not enter into any kind of agreement with the state for your testimony here today, is that correct?
No.
You do have use immunity for what you say here in court, just like any other witness.
Correct.
But you really didn't even want to be here today, isn't that correct?
Yeah, I
Further
didn't.
questions?
Okay, recross by the defense.
Ms. Osborne, the charge is pending. That's coming up for calendar call or the trial conference next week,
Correct.
April 1st.
Yes.
You have a lawyer for that case, right?
Yes.
I'm sure you discussed the case with your attorney, right?
Yes.
And your attorney knows that you're a witness in this case, right?
Correct.
In fact, you discussed, before we started the deposition in February, you were given the opportunity to contact your attorney to have them present, right?
Yes.
And you talked to the office, and then you went ahead and gave the deposition in February, correct?
Correct.
And isn't it true that your attorney would have suggested to you testifying here to help you out next week in the case?
No, they said they don't represent me at all on this case and to go ahead and testify.
But that is something that your attorney could then go to the prosecutor who has your case and say, Ms. Osborne testified to you guys in Mr. Bradley's case, right?
I guess, but that's not ever been discussed.
Because you haven't testified yet. You're testifying now.
Right, but it's never even been brought up.
But that court date is not until next week.
Correct.
Thank you.
Okay, ma'am, thank you for your testimony. You're free to step down. Okay, other witnesses on behalf of the state.
State would call Corey
What's the last name?
Crumley.
Okay. Okay, ma'am, if you'll step up before the clerk to be sworn.
You raise your right hand. Do you solemnly swear or affirm the testimony you shall give will be the truth, the whole truth, and nothing but the truth, so help you God? I do. Thank you.
Ma'am, if you'll have a seat in the witness chair. That chair does roll around as compared to other chairs, so if you'll scoot that chair up forward, do adjust that microphone, do talk into that microphone. It helps us hear your testimony. It also aids in recording your testimony. Okay, Mr. Brown.
Thank you. Ma'am, could you please state your name and spell your first and last name for the jury?
My name's Corey Crumbley, Crumbley.
And how are you employed?
I'm employed as a crime laboratory analyst with the Florida Department of Law Enforcement.
And how long have you been so employed?
Approximately 12 years.
And what are your duties?
I'm a crime laboratory analyst, so my job is to examine items of evidence for potential sources of DNA. Once identified, I perform DNA analysis on those samples.
And can you tell the jury what's your educational background and training for DNA analysis?
I have a Bachelor's of Science degree in molecular biology and microbiology from the University of Central Florida, and I completed a year-long training program at the Florida Department of Law Enforcement.
And have you previously testified as an expert in this field?
Yes, I have.
And can you tell the jury how many times and in what courts?
Approximately 35 times in Orange County, Osceola County, Volusia County, St. Martin County.
And would it even be possible to give the jury a number of items that you've examined for the potential existence of DNA?
I've performed STR testing over 3,500 times.
Now, can you tell the jury, tell them what is DNA and how is it left on an item?
DNA stands for deoxyribonucleic acid. It's your genetic blueprint. It's found in virtually every cell of your body, and within those cells, it's the same. You inherit half of your profile from your mother, half from your father. The profile is determined at conception, and it remains the same throughout your lifetime. Only identical twins will have the same DNA profile at all 13 markers that I tested for in this case. You can leave DNA behind in the form of body fluids like blood, semen, or saliva. You can also leave DNA behind in the form of skin cells if you touch or handle an item, or you could shed hairs.
Now, you indicated 13 genetic markers. What are those 13 and how do you pick those 13?
Those 13 markers were determined by a panel. They were chosen because they were fairly well characterized. They could be multiplexed very easily and used for databasing purposes.
And can you tell the jury, how do you extract DNA from it?
I use chemicals and heat.
And then once you're able to extract it, the profile, the DNA, how do you test it? What do you do with it?
After extraction, the next step is quantitation. That is a test that tells me how much DNA I've recovered. The next step is amplification. That's where I target and copy the DNA at the 13 loci and a gender identification marker. That's the PCR reaction, the polymerase chain reaction. So the DNA at those locations is copied over and over and over again. The next step is processing. That's where instrumentation detects the DNA, and the final step is analysis, and that's where I analyze the data, make comparisons and interpretations relative to the data.
And you ultimately then compare it to what is called a known DNA sample?
Yes, I take evidence DNA profiles that I obtain, and I compare them to reference standards or known DNA standards from individuals who may have been involved in the case.
And when you do that comparison, can you tell the jury, do you do a statistical analysis to make that match, and what do you do?
Yes, once two profiles are determined to match, I perform what's called a random match probability statistic. That statistic tells me what the probability is of a coincidental match between the two profiles.
And so you indicated you had the 14 genetic markers, one being the sex marker, and then the 13 other genetic markers, correct?
Correct.
And if the two samples differ in any particular genetic marker, what does that tell you?
That individual is excluded. There's no way that they donated the profile.
And then if they're the same, that's when you do the statistical analysis.
Yes.
And is the entire process that you've discussed, your extraction process, analyzing it, and then the statistical analysis, is that accepted within the scientific community?
Yes, it is.
Now, were you assigned and did you do comparisons on the case of the state of Florida versus Brandon Bradley?
I did.
Can I approach the witness?
Yes, you may.
First, I'm going to show you what is marked as Exhibit CA. You recognize that?
Yes, I do.
And how do you recognize it?
I recognize it by the FDLE case number and my initials.
And you tell the jury, did you receive that item?
Yes.
And when you received it, was it sealed?
Yes,
And did you open that particular package?
I did.
And during the time that it was open, did you have the contents exclusively within your possession?
I did.
And when you were completed with that item, did you reseal it?
Yes, I did.
And is the seal intact?
Yes, it is.
What's contained within that package?
These are buccal swabs represented as being from Brandon Bradley.
Also want to show you Exhibit CG marked for identification. You recognize that item?
Yes, I do.
And how do you recognize it?
I recognize it by the FDLE case number and my initials.
And is your seal intact?
Yes, it is.
And when you opened that item, examine the contents, was it exclusively within your possession
Yes, it was.
until you received it?
Yes.
And what is contained within that item?
A set of buccal swabs represented as being from Andrea Kirshner.
And so the jury understands, what are buccal swabs?
Buccal swabs are samples collected from the inside of an individual's cheeks. It picks up skin cells so that I can obtain a DNA profile and use that for comparison.
And I want to show you what is marked as Exhibit FD for identification. You recognize that item?
Yes, I do.
And how do you recognize it?
I recognize it by my mark, the FDLE case number, and the seal with my initials on it.
And is your seal intact?
Yes, it is.
And what is contained within that item?
This is a DNA card represented as being from Deputy Pill.
And at this time, the state would move these three items marked as the next numbered state exhibits.
Response for the defense.
Okay.
Okay, hopefully I've got the numbers right. CA will be 166, 166. CB will be 167. And FD will be 168.
Ms. Crumley, can you tell the jury what you did with each of those three items we were just discussing?
I took samples from them separately, and I performed DNA analysis on those samples.
And what was the result of that DNA analysis?
I obtained three different complete DNA profiles at all the markers that I tested for.
Next, I want to show you what is marked as exhibits E, U, and EW. Do you recognize these exhibits?
Yes, I do.
And how do you recognize those exhibits?
I recognize them by the FDLE case number and my initials.
And when you opened those, did you have those exclusively within your possession until you resealed the item?
Yes.
And is your seal intact?
Yes.
Can you tell the jury what is in each of those items, and please identify the item?
This item, States Exhibit EW, is a set of swabs from item FE5, a magazine. EU, State's Exhibit EU, appears to be a set of swabs from item FE3 from a magazine.
Your Honor, at this time, the state would move each of those marked exhibits into evidence as the next numbered state exhibits.
Response from the defense? Okay, EU will be State's Exhibit 169. EW will be State's Exhibit 170.
And did you do the analysis on each of those items, the same analysis that we've discussed already?
Yes, I did.
And can you tell the jury what was the result of your DNA analysis for those the two swabs from the magazines?
May I consult my report?
Yes. And do you need those items back? Do you need the items back to compare your report?
Yes, only because my numbers aren't the same as yours.
Just so it's correct, when these items are listed and they have an item number on here, SW21 for what is now in evidence as 169 and SW23, correct?
Yes.
And SW23 is item 170. And those are the item numbers that you use on your report, the item numbers that the police list on the package, right?
Yes, I use the agency numbers.
And have you had a chance to review your report as far as your examination for these two items?
Yes.
And can you tell the jury what was the result of your DNA examination?
I obtained no DNA profile from those items.
Next, I want to show you first what is marked as Exhibit ET, otherwise known as SW20, Exhibit EV, which is SW22, EX, which is SW24,
EX, did you say? Or ES?
EX.
EX.
yes, sir,
Okay.
EY, which was SW25, and EZ, which was SW27. Do you recognize those items?
Yes, I do.
And how do you recognize those items?
I recognize them all by the FDLE case number and my initials.
And when you obtained those items, did you and open them, did you keep them exclusively within your possession during that time?
Yes, I did.
And you reseal those items?
Yes.
And is your seal on each of those items intact?
Yes, it is.
And can you tell the jury what is in each of those items?
State's ET is a set of swabs from item FE2 from the rim and head stamp.
And when you say a head stamp, is that a casing?
It could be, yes, casing or a bullet. EV is a set of swabs from item FE4, again from a rim and head stamp. EX is a set of swabs from item FE6 from rim and head stamps again. EY is a set of swabs from FE7, rim and head stamp. And EZ is a set of swabs from FE11 from rims and head stamps.
Your Honor, the state would move those 5 items into evidence as the next numbered state exhibits.
Okay, ET will be State's Exhibit 171. EV will be State's Exhibit 172. EX will be State's Exhibit 173. EY will be States Exhibit 174, and EZ will be States Exhibit 175.
Judge, if I can ask a follow-up question before I bring those items to the court. Did you do your DNA analysis on those items?
Yes, I did.
And can you tell the jury what was the result of your analysis on those items?
I did not obtain any DNA results from these particular items.
I just want to show you what is remarked as EO and EP. Do you recognize those two items?
Yes, I do.
And how do you recognize them?
I recognize them by the FDLE case number, my initials.
And is your seal intact in those two items?
Yes, it is.
And when you open those items, did you keep them exclusively within your possession during that time until you resealed them?
Yes, I did.
And can you tell the jury what are each of those items?
EO is a set of swabs from stain PM1. EP is a set of swabs from stain at PM9.
And do you know would that be PM being photo marker or is just indicated PM?
It's just indicated PM.
Your Honor, at this time, the state would move into evidence each of those two items as the next number of state exhibits.
Response from the defense?
No objection.
EO will be States Exhibit 176. EP will be States Exhibit 177.
Ms. Crumley, did you do the DNA analysis on those two items?
Yes, I did. I first tested them for blood, though.
Okay. And what was the result of testing them for blood?
They gave chemical indication for the possible presence of blood, meaning they were positive.
And then once you did that, what was your next step in your analysis of these items?
I performed DNA analysis on samples from those items.
And did you perform the analysis that you had discussed earlier?
Yes.
And can you tell the jury what was the result of that analysis?
I obtained the same complete DNA profile from those two samples. That DNA profile was consistent with originating from a female individual, and it matched the DNA profile from Deputy Pill.
And did you do the statistical analysis to determine the possibility of a random match?
Yes, I did.
And can you tell the jury what was the result of that analysis?
The frequency of occurrence of the profile is 1 in 97 quadrillion Caucasians, 1 in 85 quadrillion African Americans, and 1 in 42 quadrillion Southeastern Hispanics.
And can you tell the jury what is a quadrillion?
A quadrillion is a 1 with 15 zeros after it.
And Ms. Crumley, how do you arrive, what database do you use to arrive at those numbers?
In this case, I used the FBI's population statistics database and software.
And is that generally accepted within the scientific community?
Yes, it is.
I just want to show you what is marked as Exhibit ES. I should examine that item. You recognize that item?
Yes.
And how do you recognize it?
I recognize it by the FDLE case number and my initials.
And is your seal intact on that item?
Yes, it is.
Did you have it exclusively within your possession during the time that you examined it?
Yes.
And what is contained within that item?
This is a set of swabs from item FE1, red-brown stain, or RBS, and yellow stains.
And did you perform a DNA analysis on that item?
Yes, after I tested it for the possible presence of blood.
Here at this time, the state would move the item into evidence as the next numbered state exhibit.
Response from the defense?
No.
ES will be State's Exhibit 178.
First, can you tell the jury, Ms. Crumpley, what was your results of your test for blood?
That exhibit failed to give chemical indications for the possible presence of blood. The test was negative.
And then after that, what was the next step that you performed?
I performed DNA analysis on a sample from that swab.
Can you tell the jury, were you able to obtain a DNA profile?
I obtained a partial DNA profile from that exhibit.
Can you explain to the jury what is a partial DNA profile?
A complete DNA profile is DNA results at all 13 of the locations or markers that I test for. A partial profile is a DNA profile of less than that. So in this case, I had results at 4 locations that I test for, so it's a partial profile in that respect.
And when you had that, did you compare that profile to the DNA profile of Barbara Pill?
Yes,
And what was the result?
she is excluded.
And when you exclude somebody, does that mean her profile would not match at those 4 genetic markers that you were testing?
Yes,
And did you also compare it to the sample of Andrea Kirsch?
yes,
And what was the result there?
she was also excluded.
And did you compare it to the result for the DNA profile for Brandon Bradley?
Yes,
And what was your result?
it was a match to the DNA profile from Brandon Bradley.
Did you also do the statistical analysis for that match?
Yes.
And can you tell the jury what was the result of that?
For the 4 loci that I obtained results for, the frequency of occurrence of the profile is 1 in 300,000 Caucasians, 1 in 220,000 African Americans, and 1 in 840,000 Southeastern Hispanics.
And can you tell the jury the prior match was 1 in 97 quadrillion for Caucasians, this for African Americans is 1 in 220,000. Why the difference?
Because previously I had a DNA profile at all 13 of the areas that I test for. So I could use all of those locations in order to calculate the statistic. In this case, I had results at 4 locations, so the statistical analysis is done at only these 4.
I just want to show you what has been marked as Exhibit ER for identification. Do you recognize that exhibit?
Yes, I do.
Again, how do you recognize it?
From the FDLE case number and my initials.
And what is that exhibit?
This is a set of swabs from item FE1 muzzle.
And did you have that item exclusively within your possession when you opened it
Yes, I did.
until you resealed it?
Yes.
And is your seal intact?
Yes.
And at this time, the state would move to offer that item into evidence as the next numbered state exhibit.
Response from the defense? ER will be received as State's 179.
And did you perform your DNA analysis on that item?
Yes.
And can you tell the jury what was your result?
I first tested it again for the possible presence of blood. That test was negative. Then I performed DNA testing on that sample and obtained a DNA profile from at least 2 individuals. The sample was a mixture. It was a very limited sample. I didn't have that much information to work with, so it was insufficient for inclusion purposes, but may have been suitable for exclusion purposes.
And were you able to do anything with
I compared it to the DNA profiles from the DNA standards that I obtained in the case, and I was not able to make any determinations about who may have donated to that mixture.
And when you indicate that it's insufficient amount, can you tell the jury what does that mean?
It just means that there wasn't enough DNA left behind for me to get enough information to say anything about who may have donated to the particular sample.
I next want to show you what is marked as Exhibit EQ. Do you recognize that exhibit?
Yes, I do.
And how do you recognize that?
By the FDLE case number and my initials.
And when you opened that exhibit, did you keep it within your exclusive possession during the entire time until you resealed it?
Yes.
And is your seal attached?
Yes, it is.
And can you tell the jury what is that exhibit?
This item is a set of swabs from item FE1, textured areas, and trigger.
And at this time, the state would move that item into evidence as the next numbered state exhibit.
Response from the defense? Okay, EQ will be received as State's Exhibit 180.
Your Honor, I also want to show this currently exhibit number 124, which is a firearm. And can you tell the jury what item number is on that exhibit?
Item FE1.
And is that where the previous swabbings, but exhibit, the last exhibit, EQ that we just admitted, swabbing from textured areas and trigger, to indicate that it came from this exhibit?
Yes, it does.
And did you, on that exhibit, did you indicate that you tested for blood?
No, I did not.
Okay. And what did you then do with the swabbings that came from the textured area and trigger of the hand?
I performed DNA testing.
And were you able to obtain a DNA profile?
Yes.
Was it a complete profile?
Yes, it was a complete profile, but it was a mixed profile. So again, mixture is a DNA profile that is comprised of more than one contributor. In this particular case, I was able to distinguish one of the contributors from the other contributor because that individual was donating a lot more DNA to the sample. That's what we call the major contributor. So I was able to determine that the major contributor was male and matched the DNA profile from Brandon Bradley.
As far as the minor contributor, did you compare that to both Deputy Pill, first Deputy Pill?
Yes, I did not have enough information relative to the minor contributor to make a determination about Deputy Pill, but Andrea Kirshner is excluded.
So the second contributor could be Deputy Pill, but you cannot make any determination.
That is correct.
And DNA, can that come from sweat?
Can come from sweat, skin cells left behind when you handle a particular item. If you're talking to someone, you may spit on them in terms of a little bit of spray, and the saliva contains skin cells just like when you touch something, so that can also be transferred.
And how about any other type of matter from the body? Brain cells, anything like that, body matter?
Pretty much anything.
And as far as, did you compare it to Andrea Kirchner?
The limited,
Yes, the minor contributor.
she was excluded.
And did you indicated you compared it to the DNA profile of Brandon Bradley?
Yes,
And what was your conclusion there?
he was a match to the profile.
And did you do the statistical analysis?
Yes, I did.
And can you tell the jury what were the results of the statistical analysis?
Sorry, I have to find it on here. It was calculated under a different sample. The frequency of occurrence of the profile is 1 in 37 quadrillion Caucasians, 1 in 35 quadrillion African Americans, and 1 in 290 quadrillion Southeastern Hispanics.
Madam, I have one moment.
Yes, you may.
No further questions, Your Honor.
Okay, cross-examination by the defense. Okay, ma'am, thank you for your testimony. You're free to step down. Okay, if I could have a bench conference? Okay, other witnesses on behalf of the state?
State restaurant.
Okay. Ladies and gentlemen of the jury, we have some matters that we need to discuss outside your presence, and this is the appropriate time to do that. So I'm going to allow you to take an early lunch, and you're going to be on recess until 1 o'clock. During this recess, you must continue to abide by the rules governing your service as a juror. So for the jury, court will be in recess until 1 p.m. Report to the jury assembly room at that time. Okay, thank you.
All right.
Okay, please be seated. We'll go ahead and take our morning recess since we've been here since 8:30, so we'll take a 15-minute recess, and if you'll be back at 10:45, we'll do the motions, any motions. Okay, court will be in recess for 15 minutes. Thank you.